Now call the fourth case on this morning's docket. That is case number 111235, FBI v. Kalavag et al.
May it please the court. Nancy Wilson on behalf of Appellant FBI. May I ask for a rebuttal of 4 minutes, please?
4 minutes is granted.
Thank you. Kansas Statute 582323 reads, assignment carries debt secured. The assignment of any mortgage, as herein provided, shall carry with it the debt secured. The issue now is whether application of the statute requires reversal of the Court of Appeals decision, and that decision was that Appellant FBI could not enforce a debt, even though it had a valid assignment of mortgage.
Specifically about the note, wasn't it? Could not enforce the note. Is that different from
Yes.
debt?
No, it is not different under Kansas law in my view. A couple of recent cases like that we've cited are Christensen and Chilcote, and they treat the note as equal to the debt. In those particular cases, they were analyzing whether the note gives the right to enforce, whether the foreclosing lender had the right to enforce the debt versus the note. Opposing counsel had raised that argument, and the court said, no, it's the same. So mortgage follows debt is not anything different from mortgage follows note in light of existing Kansas law.
It's the other way around that matters to you, though, isn't it?
I'm sorry?
It's the note following the mortgage or the debt following the mortgage that's important to you in this case, right?
Yes, the note following the mortgage, yes, which I would say is the same as the debt following the mortgage under Chilcote, Christensen, and other cases.
Would you agree that your client has to be able to show entitlement to enforcement under both 582323 and the UCC?
I would say it's an element of Kansas foreclosure law that the plaintiff has to be the holder of both the note and the mortgage. So it's not so much compliance with 582323, but if you have an assignment of mortgage, then that carries the debt with it and gives you the right to enforce. So it's not so much that the client had to comply with it, but the client did have an assignment of mortgage.
That's undisputed. The dispute is all about the note.
Yes.
So I think what I intended to ask, and if I didn't state it very understandably, I apologize, but you do also have to show that you're the holder of the note under
Yes,
the UCC or a non-holder with rights to enforce under a couple of other sections of the UCC. You're claiming to be the holder.
Yes.
And you're claiming to be the holder because of the blank endorsement. Is that correct?
Well, we're claiming to be the holder by two alternative paths if you look at prior case law. So to answer your question, yes, we have to show we're holder of both note and mortgage, but I think that Kansas Courts of Appeals have treated it as if you can get there by two alternative paths, and one would be through assignment of the mortgage under 582323, and the other would be compliance with the UCC. And they have treated them even-handedly and believe that both of those would show the ability to enforce the note and the
So
debt.
they're alternative, not joint. You don't have to meet both.
Yes, because if they were joint, I don't know what the purpose of 582323 would even be. So if the statute means what it says it means, then the decision should be reversed in favor of FBI. Here are the facts to which we're applying the statute. GMAC Bank made a $450,000 loan to the Kalavigs. At the same time, Bank of the Prairie had a large loan out to the Kalavigs, which it subordinated. After that, it made even more loans secured by the same property, so it voluntarily assumed second place. In 2011, FBI started foreclosure on what had originally been the GMAC Bank loan. So with Bank of the Prairie in junior position, by its own choice, it would get nothing and could get wiped out if the property were foreclosed and were not valuable enough to cover all the outstanding loans. The property was sold before trial to a third party, so this suit became a dispute between two lenders as to who gets a limited fund of money. FVI came to trial with the original mortgage and assignment of mortgage to itself. Both of them came into evidence, no problem. And under 582323, that should have given it the right to enforce the debt as well.
Excuse me, could I have you back up, counsel? You said both came into evidence with no problem. You're talking about the mortgage assignment and what else?
And the mortgage.
The mortgage.
Original
But
mortgage and
But
original
the dispute
assignment.
in this case is whether there was sufficient evidence of the note and of you being holder of the note. Isn't that right?
That was the dispute before the Court of Appeals.
Right. And who has the burden to show that, and when do they have it, and how do they show it?
The plaintiff in a foreclosure case would have the burden to show holder status. However, it turned into a trial kind of FVI's burden to show the lack of a split. It's not FVI's burden to show a negative. FVI did what many, many other foreclosing plaintiffs have done. It came to trial and said, here is the original note. It has on it original endorsements, and the last one is an endorsement in blank. And the trial court would not accept that into evidence. So then Bank of the Prairie raised a lot of questions and speculations, not evidence, about whether the endorsements were sufficient. And so the trial court, and Bank of the Prairie got the trial court to do this, basically shifted the burden over to FVI to show the lack of a split in the instruments and that the endorsements were valid. That wasn't FVI's burden properly. The original note with endorsements, in line with many other Kansas cases, should have been simply accepted into evidence without the additional evidentiary burdens. So,
Bringing them to trial was sufficient. You didn't have to have them attached to your petition?
yes, Your Honor, it did not have to be attached to the petition. That's happened in many other cases as well.
I understand it's happened in many other cases, and it may be the commercial practice.
Yes,
But do you have any cases to that effect?
yes.
That that's adequate?
Yes. The same thing happened in the Conde, Massey, in INDA, Bank of America versus INDA. And this was all even at the summary judgment stage. This is informal. This is not requiring a witness, as Bank of the Prairie would have, to testify about each and every endorsement and assignment along the way. This is simply coming to court and saying, here it is, and the trial court says, okay.
And why does that not have to be authenticated?
Well, for one thing, the endorsements are self-authenticating. And for another thing, I believe that the trial courts are recognizing that it's by operation of law. In other words, holder status under the UCC is established if you have the original note and an endorsement in blank. And it doesn't take witnesses, it doesn't take foundation, there's no hearsay argument, none of that. It's just what it is. And I think that there's a line of Kansas cases. There are increasingly developing Kansas Court of Appeals cases where that is what is done. So the trial judge ended up finding FVI's lien to be unenforceable by anyone and moved Bank of the Prairie up into first place. And this was all contrary to Kansas law as it existed and as it exists now, as it's been developing. And the Court of Appeals affirmed. So those are the pertinent facts. And FVI's interpretation is in line with Kansas foreclosure law and the rules of statutory interpretation in Kansas. We know that establishing the right to enforce the note means also having the right to enforce the mortgage. The cases all say the mortgage follows the note. And what they mean by follows is the foreclosing plaintiff can enforce the note. But the converse is also true, and numerous cases say that. McConnell, for example. The note follows the mortgage. So the right to enforce the mortgage also means having the right to enforce the note. There are cases cited in our supplemental brief at 5. There's also MetLife versus Hansen at 48 Can. App. 2nd, 213. Hansen specifically cites and quotes the statute for that proposition. So the right to enforce the debt can come from the right to enforce the note under the UCC, or the other way around, under 582323, both by operation of law. FVI's interpretation is consistent with Kansas principles of statutory construction as well. Statute must be applied according to its plain language if it's clear and unambiguous. And in this case, yes, it is. Having an assignment means carrying the debt with it. We have to avoid unreasonable results. 582323 must mean that the debt is enforceable by the assignee, or else any other interpretation renders the statute useless or meaningless, and there is a presumption against the legislature enacting useless or meaningless legislation. And we can't add extra words. If we add, yes, you can enforce the mortgage if you have an assignment, but also you have to meet all the UCC requirements, then that's adding words and it's adding an exception. Instead, the two statutes need to be read in harmony, as Kansas courts have done. Cases where that's been done include Tomlinson and Massey. In Tomlinson, the borrower challenged the note because the copy of it attached to the petition did not have an endorsement in specific to the lender or in blank. And the court said, in the absence of any evidence from the borrower controverting facts, we think there is at least prima facie evidence that U.S. Bank is the holder of the note. But, said the court, even if we're wrong about that, there's this assignment of mortgage that carries the debt with it. And in Massey, the borrower said, hey, lender, you've only got an assignment of mortgage. That doesn't give you the right to enforce anything. And the court said, no, that's wrong. You can enforce the debt. So Kansas appellate courts read the two statutes even-handedly, harmoniously, and together. What this is Bank of the Prairie's buyer's remorse. It does not want to be second, and it's asking for new and different law so that it doesn't have to be second. FVI's request is that the court apply the law the way it always has been since 1899. Not anything new and not anything different. So we ask for reversal of the Court of Appeals decision, judgment in favor of FVI.
You're wanting us, this is here on summary judgment in favor of BOP, correct?
No, Your Honor, I may have confused you. If so, I apologize. It was a trial in favor of Bank of the Prairie. So there is a journal entry of judgment where the trial court lays out all its reasons for a ruling in favor of Bank of the Prairie.
Any more questions? Thank you, counsel.
If it please the court, my name is Tim Gerard and I appear for Bank of the Prairie Appellate. When this court granted the petition for review, it asked the parties to be prepared to address the impact of KSA 582323. So my comments, like counsel's, will be directed primarily toward that statute. Bank of the Prairie's short response with regard to 582323 is that its application or its existence does not affect the outcome of this case. And before I get to some other thoughts on why that is our position, I did, though, want to say that, actually make the first point, which is that I'm aware and understand that in Kansas, the law wants a mortgage and the obligations to, or I'm sorry, and the enforcement right and the obligation that the mortgage secures to stay together. I understand that that's a strong tenet of Kansas law. But equally clear in Kansas is that if one does not have enforcement rights in the debt instrument, then that party cannot enforce the mortgage. And that's what this case is about. This was a case in which the foreclosing plaintiff asserted rights in a promissory note based on, asserted rights in a promissory note at trial. And based on the theories that it chose and that it asserted, it failed to prove at trial that it had rights in the promissory note. Those theories were under Article 3 of the Uniform Commercial Code, under which the foreclosing plaintiff said that it had enforcement rights as a holder of the promissory note pursuant to KSA 833-301A.
So you're saying it had the burden at trial to show it was a holder under the UCC?
Yes.
And just coming forward with the original note and a blank endorsement doesn't do that?
No, but more specifically, when they say that they came forward with the original note of the endorsements or blank endorsements, what they fail to point out, I suppose, is that the alleged endorsement in blank wasn't admitted into evidence. And so what was admitted into evidence was an original promissory note that was, initially, the lender was GMAC Bank, and the note on its face purported to be endorsed to GMAC B Asset Management Corp., and that's what was admitted into evidence, not a promissory note that was payable to FBI or in blank.
Right. The judge excluded some of the later endorsements, correct? The copy of the note that had the later endorsements.
Correct.
Okay. So let's just talk about that evidentiary ruling.
Mm-hmm.
Why was the judge right?
I'm sorry.
Why was the judge right on that?
Well, there were a number of reasons, but the objection that we made to the entry into admission of the alleged endorsement in blank, which was a second endorsement that followed the endorsement to GMAC Asset Management Corp. But in any event, we objected based on lack of foundation and as containing hearsay. And in fact, the FBI witness testified at trial as to those endorsements. And after the FBI witness testified, the FBI witness testimony on those alleged endorsements was really lacking. It amounted to that witness didn't know who had placed these extra stamps on a promissory note, which, by the way, weren't in the form of the promissory note that was attached to the petition when the case was filed. This was a new form of the promissory note that showed up in March of
It showed up later.
9 months later, after the case had
It
been
showed
filed.
up later, but that wasn't in evidence, was it?
I'm sorry?
The fact that it showed up later wasn't in evidence, was it? There wasn't any evidence put on about that, was there?
Not evidence specifically as to that point.
No testimony on that point.
No, but that
The only
too-
way that the court would have known that was based on your argument.
That's
and
true.
the content of the court file, correct?
Mhm.
Let's talk about foundation and hearsay. You said you objected on the basis of foundation and hearsay, is that right?
Yes,
Could you just
lack,
explain those two objections to me?
lack of
Hearsay was business records, wasn't it? Why didn't it meet the business records exception?
because there wasn't foundation for the
Do you
alleged
think they're equivalent, or are they two different objections?
two different objections.
Okay, explain to me how they're different then. If you say that the hearsay objection, the lack of an exception to hearsay is proven by the lack of foundation, how are they different?
Well, in the instance in which we're talking about hearsay, we're talking, of course, about something that's been offered by the out-of-court declarant to prove the truth of the matter.
Sure.
And in this particular instance, what they were doing was trying to introduce stamps, again, that were not part of the original filing that showed up, well, sometimes after the case had been filed, but through a witness that couldn't testify as to the people who had put the stamps there, whether they had authority, whether they had knowledge of the loan.
Do most business records come in because the person who's sponsoring the evidence has a witness who can testify about being there or having personal knowledge or knowing that the individual who made, for example, a doctor's note is who they say they are and has authority? I mean, business records are pretty perfunctory admissions in most cases, aren't they, counsel?
I think they probably are.
Right.
In this case, we've got unique facts where, again, they had, by the time we got to trial, asserted that they also, this is a contrary and different theory that they had asserted. They
I
asserted,
understand there had been inconsistent or filings that you view as inconsistent in the district court. I understand that. And I understand that there had been positions taken prior to trial that were inconsistent. But how do those facts make that record inadmissible? Make that note inadmissible at trial? Don't they
Again,
just question credibility? But they don't make it inadmissible, do they?
to the extent that they were offering these alleged stamps as proof.
Well, they
of
are
that-
stamps. We can all see that, right?
Yes,
Okay.
and they acknowledged that in the summary judgment process as part of the case. But to the extent that they're offering those, they're offering them to prove that the promissory note had in fact been endorsed. This wasn't a matter of, we didn't acknowledge or ever admit or concede that these alleged stamps were even endorsements. This was a matter of that they were offering them solely for the purpose of showing that there had been an endorsement. And
But
again,
the question is, Counselor, why doesn't that argument go to the weight and credibility of the document rather than its admissibility? I believe that's the question. You're arguing that these are not valid. They're not. These don't prove what you say they prove. And why isn't that a factual determination for the trier of fact to make rather than a gatekeeping function for the court on admissibility?
Well, no, I think it is for the trial court to determine based on weight and credibility, and the trial court's determination in this instance was, after FEI's witnesses' testimony on the matter, the trial court made the observation.
But,
I'm sorry,
okay, maybe I misunderstood. I thought the trial court ruled that would not be admissible. That copy with the endorsements would not be admissible, rather than they were not credible, which is two different things, don't you agree?
Yes, and actually, my belief is that the trial court ruled both, that it wasn't admissible and that the witness who testified on the matter wasn't credible or reliable. In fact, concluded after the witness's testimony, we have no idea when or under what circumstances these stamps may have even been put on this document. I mean, that was the court's observation, which is pretty resounding given the witness testimony, which was FBI's witness, by the way, in trying to prove that the promissory note had been endorsed. But there was an objection based on hearsay, which was granted, and then also lack of foundation. And again, on the lack of foundation matter, the witness couldn't testify, didn't have any knowledge of these stamps, where they had come from, who had put them there, whether there was authority to put them there, whether the person who put them there had any knowledge. There was a complete absence of any helpful evidence or testimony on the issue of where those stamps had come from.
But the witness also testified that these stamps were business as usual, right?
Actually, the witness didn't really testify that way. The witness testified that he hadn't become involved. The gentleman's name was Andy Chatfield, and
Right.
he was part of a servicing company. And his testimony was he hadn't become involved in the loan until January of 2012. This case was filed in June of 2011.
Right, I
So-
understand he couldn't testify to the stamps on this document, but he could testify to the business practices, couldn't he? And didn't he do so?
He attempted to, yes. And he left the court believing that he lacked clarity and certainty in his testimony.
Just so
What
I'm,
do
just so I'm clear, you took exception to the claim that these were business records exceptions to hearsay. Is that right?
It was never really brought up that they didn't really assert a business records exception, but it had, in my view, would have been that they didn't show foundation for the stamps, and so that therefore they wouldn't have qualified.
But, okay, to put that argument aside then, your argument is that insufficient foundation was shown to admit these documents into evidence.
Absolutely.
Is that right?
Yes, sir.
Okay. And the trial court agreed with you saying insufficient foundation, therefore they are not admitted.
That's
Is that
correct.
right?
Yes. Thank you.
And when I asked counsel, her response was the endorsements are self-authenticating. Why is that not a sufficient?
Well, interestingly, what they were relying on at the time would have been KSA 843308, which is a uniform commercial code provision that talks about signatures being presumed to be valid, except that if there's a dispute as to the signature, then the presumption can be overcome. Bank of the Prairie, of course, disputed the validity of the signatures, and with regard to the evidence that the court found in terms of there being no presumption worthy of these alleged stamps, it included, again, that they had showed up significantly after the case had been filed, but that FBI had also relied in the meantime on the note that was attached to the petition. In fact, in October of 2011 in this case, they filed a motion to dismiss Bank of the Prairie's counterclaim, and in the motion to dismiss, they again relied on the promissory note that was attached to the petition that didn't have these alleged stamps on it. And at that time, they were saying, well, it's endorsed to us, except that it wasn't. Beyond that, they admitted in a May 2nd, 2012 status conference with the court that their position on enforcement was based on an allonge giving them a specific endorsement to them and was not based on an endorsement in blank. They relied on the allonge and the stamps inconsistently because either would have come through a party other than GMACB, which was the endorsee on the promissory note, and had GMACB transferred the rights to either one of those parties, it couldn't have transferred it to the other. But they argued both positions at the same time, which were inconsistent. Ultimately,
So those were all behaviors in the case. But how did they go to the validity of the endorsements as opposed to inconsistent positions taken by counsel who seem to be having trouble finding their way?
Well, and then ultimately, the witness who testified actually testified that had he known, this is the witness at trial, of course, had he known about the allonge position in October 2011 when they were seeking to dismiss Bank of the Prairie's counterclaim, they would have relied on the allonge, and that was his testimony. And then, of course, with regard to the stamps themselves, as I've talked about, he basically testified, Mr. Chapman testified that he had no idea whether they were authentic or authorized and testimony of that nature. So in that regard, the court determined that the signatures weren't entitled to the presumption of existence because there had been facts introduced that showed the finding could be supported that they weren't authentic.
To have satisfied you and what you believe was the foundation requirement, how many different stamps or endorsements or signatures would have had to been proven by a witness?
The two that the court excluded, the note was set up like this. It was, again, the lender was GMAC Bank,
Right.
which had endorsed to GMACB. The alleged stamps that were excluded at trial and inadmissible at trial would have purportedly been one from GMACB to Residential Funding Company, and then there was a second that was purportedly Residential Funding in blank. But again, with regard to the first of those from GMACB, that was allegedly from GMACB to Residential Funding, the witness who testified on the matter couldn't, the stamp was in the name of Michael Geller was the name, and the witness said, I don't know that gentleman, I don't know his signature, I can't say who put that stamp there, I can't say he put it there, I can't say it's his genuine signature.
So if Michael Geller had testified that's my signature, that would have satisfied that part of your objection. Is that right?
I guess generally, yes.
Okay. And then what about from we talked about GMACB to Residential Funding and then another one.
And then Residential Funding in blank, and that stamp was in the name of Patricia Taylor, and the witness's testimony was pretty much identical with regard to that.
So Patricia Taylor getting on the stand and saying, yes, that's my work, that would have satisfied that part of your objection to foundation.
Yes.
Okay, so it's your position those two witnesses would have needed to come in and say that.
Yes.
All right, thank you.
I'm running short on time. I wanted to shift back to the 582323 argument real quick. This case was tried under the Uniform Commercial Code, Article 9. FBI's position at trial was not that it had enforcement rights in the promissory note exclusively by virtue of 582323. And to the extent that was not the position at trial and was raised only on appeal, it had been inappropriate to raise it, and would we respectfully request that the court not entertain that argument. But even if it had been their argument that 582323, even if that is their argument, that gives exclusive rights to enforce, or that it gives rights to enforce a promissory note, our position is that that's an ill-fated argument. And the reason for that is because this case involved an undisputed negotiable instrument. Negotiable instruments are subject to the Uniform Commercial Code. Therefore, the promissory note in this case was subject to the Uniform Commercial Code. And we know because of this court's decision in the Chilson against Capital Bank of Miami case that the Uniform Commercial Code displaces the prior law, and the prior law now acts to supplement the UCC provisions when they're silent. In this case, the UCC provisions regarding who is entitled to enforce a promissory note are not silent. In fact, 843301 talks about who can enforce or who is entitled to enforce a promissory note. And that provision tells us that it can be a holder of the note, which is what FBI asserted at trial and was our argument at trial. But to find out who a holder is, you have to look at the Uniform Commercial Code. And the Uniform Commercial Code tells you that it's someone that is in possession of the note. And the note is either made to it or endorsed to it, or could be endorsed in blank. But in order to determine whether any of those things, whether there's an endorsement or whether there's been a transfer to the recipient or the holder, you've got to again look back to the Uniform Commercial Code and look at the provisions that relate to, in this case, it would have been negotiation of the note, endorsement, and things of that nature. None of the provisions in the Uniform Commercial Code and those terminologies that relate to the requirements for who is entitled to enforce a promissory note are found in KSA 582323. None of them. In fact, KSA 582323 doesn't even say that when a mortgage is transferred, the note that is thereby secured goes with it. It says the debt. Unlike, by the way, the Rhode Island statute that FBI
Did
cited.
FBI have the original note?
The first time that they produced it was at the trial.
Did they have the original note?
Yes, sir.
And if it's a negotiable instrument, can anyone else be a holder of that if they don't have the original note without an assignment or power of attorney or some other?
Actually, under 843301, they've got to be a holder of the note, which again requires that they're in possession and have endorsement, the proper endorsement, or they could be a
But
non-holder.
my question is, if FBI had physical possession of the original of the note, is there a possibility that anyone else in the universe could have been a holder of the note?
No,
And so there would just be no one that held the note, under your theory?
that's correct. And
The note had extinguished itself for lack of foundation on the endorsement.
well, the note that was admitted into evidence was payable to GMACB, and they weren't a party to the case. And I don't know whether they existed. That's not in the record.
But they couldn't, they would not be a holder of that without possession of the note. Without physical possession of the original note, GMACB is not a holder.
I think they would have to have possession of the note. That's correct. So I'm going to wrap up because I know I'm past my time, and unless the court has some other questions. This was a case tried under the Uniform Commercial Code. In fact, when they didn't prevail at trial, FBI actually attempted to assert a non-holder's position, but again, that was a position based on the Uniform Commercial Code. It didn't, even after failing at trial, turn to KSA 582323 to make the argument that, well, under that particular statute, we had enforcement rights in the note.
I just want to talk a little bit about the significance of them taking, you're talking about the position they took in their suggested findings and conclusions, right?
Correct.
Isn't it understandable they would take that position in their suggested findings and conclusions once the judge had refused to admit the evidence that they were the holder?
Well, the problem, of course, is that we tried the case based on that they were the holder. They didn't assert a non-holder position going into the trial
understand.
or ahead of the trial, so we didn't have a chance to defend the non-holder position. It wasn't part of the case. We tried a case based on a holder position. I'm grateful for the court's time, and respectfully, we would ask that the Court of Appeals decision be affirmed.
Any more questions? Thank you, counsel.
Thank you.
I just want to address a few narrow points. As to the fact that FEI changed position different times, had different versions of documents, sometimes that happens in litigation, as we all know. It definitely happened in cases we cited, Akande, Massey. There was confusion about different versions of the notes, the affidavits, wrong versions of ledgers. None of that mattered in those cases. The lender still had the right to enforce. And it's part of a growing body, I would say, of Kansas case law. As far as the validity of the endorsements, it takes actual evidence to challenge validity. It's not enough of a dispute to say, well, we don't believe those might be real. You have to actually produce your own evidence to say they're not valid. Hansen, MetLife versus Hansen, a great example of this. And the court found that the argument that there wasn't holder status did not work. You can't just use speculation and questions. And we briefed this in our appellate brief at 24, supplemental brief at 11. But in Hansen, what the court focused on was the evidence of intent to keep the note and mortgage together. For example, the note and mortgage cross-referenced each other. And we have briefed all of this as well. Most of what we're talking about is in our briefs, and then we'll drag the court all the way back through all of it, but it's there. The Court of Appeals did affirm, but they affirmed on the basis of a failure of FBI to prove standing as of the time of filing. That was the narrow focus. So it didn't talk about evidentiary failures at trial. It didn't talk about standing as of the time of trial. It didn't talk about whether the original note with the endorsement should have just been taken into evidence. It talked about standing as of the time of trial. And FBI did make this argument.
You mean as of the time of filing?
Yeah. You meant filing, didn't you, in your last statement there?
I'm sorry. Yes, as of the time
Standing
of
is the
filing.
time of filing.
Thank you. Yes. And FBI did make this argument about 582323 without citing to the statute. It did say, hey, we had an assignment of mortgage, and that should have carried with it the debt. And we made this argument in our closing argument and in our appellate brief before we brought this case up to this court.
And that argument for you wins only if you have shown that there is a cross-reference between the mortgage and the note, correct?
I would say the statute says what it says. So it says assignment carries with it the debt secured thereby. So the assignment alone, in theory, should have done it. But the Hansen court found it very persuasive and helpful that there was intent to keep the two instruments together. And other courts have said this as well. So it's courts, what I find is they'll look at a number of things. They won't maybe focus just narrowly on just the statute, but they'll pull in all the different ideas and pieces of evidence that support holder status.
So would, in this case, the Bank of the Prairie just be prohibited from trying to argue that the endorsements that they argue about, that's just a non-starter? The judge says, sit down, counsel, we're not going to listen to that because I'm looking at your interpretation of the statute.
I think the court could and should listen to it if they had evidence. We think this person didn't really sign it. We doubt this signature because we had a handwriting expert look at it, something like that, something that actually would prove invalidity of the endorsements. But without that, they are self-authenticating. They come in. The point of the endorsement is not what it says. It's the fact that it exists. And I would say 582323 has to mean something. By counsel's interpretation, it wouldn't mean anything in this case. And it was enacted long before the UCC. It's still valid. Courts cite it all the time, even-handedly with the UCC. So I don't think it's correct to use evidentiary arguments to try to use the UCC to invalidate an entire loan. The loan is still valid and good. And we ask for judgment in favor of FEI.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.